Welcome everyone, and thank you so much for joining us for this panel on the international dimensions of the Russian invasion of Ukraine. My name is Dmitry Gozobinsky. I'm the Executive Director of the Geneva Trade Platform, and it is my privilege to convene something that we frankly need more of, a panel of Ukrainians talking about the Ukrainian experience and offering their unique expertise and perspectives on a war that is transforming the entire global landscape, in addition to utterly devastating the country of Ukraine. So without too much preamble, allow me to present our eminent panel for today. We have, and I apologize for reading this to make sure I get the titles right, we have Darina Abukomova, Associate Professor at Yaroslav Mudry National Law University. Next to her, we have Olesya Krivetska, counsel at Astas and lawyer and specializing in disputes. And finally, on my immediate right, we have Irina Bogdanova, a postdoctoral researcher at the World Trade Institute at the University of Bern, WTI being a great friend of Geneva and the Geneva trade ecosystem. Today we have a relatively short time, and I'd like to spend as much time as possible with our panelists speaking. We have a focus on the law aspect of the war, but it's impossible to forget that the war is also intensely personal, especially for our panelists and indeed all Ukrainians. So in asking our panelists to share their expertise, I will also be opening the floor and in fact inviting them to share any personal reflections, stories, anecdotes, anything that they would like to say in a forum like this about how this invasion has touched them, transformed their lives, and their hopes for the future. So we might begin with the general international law question, and we'll turn to Darina, who's an international law specialist. Darina, the floor is yours, really.
Thank you very much, Dmitry, thank you. And thank you so much for this kind invitation, yes, and for holding this event. And I'm really honored to be the part of this event. And thank you for all those who are interested in Ukraine and who support our country because we need it now the most. And as you know, that on 24th of February, the Russian Federation launched a full-scale invasion of Ukraine by land, air, and sea. And it is the biggest attack by one state against another in Europe after the Second World War. And even the presence of the United Nations Secretary General in Kiev in April, after the liberation of Kiev, didn't stop Russia from shelling our capital. And actually I'm from Kharkiv, and this is the most eastern city in Ukraine, and Kharkiv is under the constant Russian bombardments since the beginning of the war. And actually I was staying there for 3 weeks since the 24th of February, and saw all those bombardments, shelling, and Russian military planes that dropped the bombs on the civilian objects, on the hospitals, on kindergartens, on schools. Actually on the slide, yes, next slide, on the slide you can see Kharkiv regional administration building before and after Russian missile hit there and killed 29 people, and among which there were also my student, and actually she was a volunteer there in the city regional administration building from the first day of war, and she died there. And hundreds of people were injured, and dozen died in the first days of Russia's attack. 7 deaths and 40 wounded were confirmed in the very first hours of Russian military attack. And from the first day of war, apartment houses, schools, kindergartens, so civilian buildings, yes, civilian objects were the primary targets of Russia. And Russian jet purposefully bomb electrical power plants and water pumps, leaving entire districts without light and without water. And unfortunately, shelling and bombing are still going on along the entire front line and in Kharkiv as well. And on the next slide, on the photos, you can see my hometown, yes, my native city Kharkiv looks now. And actually today there is no place in Ukraine that can be considered totally and completely safe, because no one knows where the next bomb will fall and where the next shelling will take place. And actually by starting the war against Ukraine, Russia violated all possible norms and principles of international law, starting with the United Nations Charter, yes, starting with the principle of prohibition of use of force and a strict prohibition of the acquisition of territory by force, and ending with the main principles and norms of international humanitarian law, yes, regarding the principle of protection of civilian population, of civilian objects, and respect of human rights. And taking all these into account, Russia must be held liable for all those illegal actions and international crimes that it commits on the territory of Ukraine. And actually now Ukraine and Ukrainian military forces, they show amazing courage and resistance. And Ukraine now effectively defends not only itself, but also European borders, European values, and Europe as a whole. And my country is now fighting for peace, but suffering from war, unfortunately. And Ukraine's fight back is not just on the battlefield, but also on the legal field. And it's very important to understand that Ukraine, unlike Russia, has always followed and will follow the norms of international law. And since the annexation of Crimea in 2014, Ukraine has opened a judicial front against Moscow, using all possible levers to bring perpetrators of war crimes to justice, from the simple soldier to the head of the Kremlin and the Russian state itself. And that is why I would like to pay your attention on international legal responsibility of Russia and bringing its top officials to international criminal responsibility. And in my speech today, I will focus briefly on international judicial mechanisms under which such international responsibility could be possible. So, this is the next slide. So currently, Ukraine uses three international judicial mechanisms. So it is the International Court of Justice, International Criminal Court, and European Court of Human Rights. And now the discussion begins regarding the creation of the special ad hoc criminal tribunal. It's like the special tribunal for the crime of aggression against Ukraine. And I would like to briefly discuss and describe the cases which are pending and some challenges that we face. So I will start from the International Court of Justice. It's ICJ, and International Court of Justice, or ICJ, is the principal organ of the United Nations. And it was established by the United Nations Charter in June 1945 and began its activities in April 1946. And the court is composed of 15 judges elected for a 9-year term by the General Assembly and the Security Council of the United Nations. And the seat of this court is the Peace Palace in The Hague, and on the slide you can see the building of the Peace Palace and of this International Court of Justice. And the court, it had twofold role. So the first, to settle in accordance with the international law legal disputes submitted to it by the states, and judgments of the ICJ in such cases have binding force and are without appeal for the parties concerned. And second, it's to give advisory opinions on legal questions referred to it by duly authorized United Nations organs and specialized agencies of the United Nations system. And as you know, Ukraine and Russia both are state parties of the statute of the International Court of Justice, and the Article 36 of the statute gives the ICJ wide judicial and jurisdiction-wide jurisdiction over all case which the parties refer to it, and all matters specially provided for in treaties and conventions that are binding for them and that are in force. And actually nowadays there are two cases pending in ICJ that were initiated by Ukraine. And the first, it deals with the genocide which is committed now in Ukraine by Russia according to the Convention on the Prevention on Punishments of the Crime of Genocide, and this convention also called like the Genocide Convention of 1948. And this convention was ratified by both Russia and Ukraine. And the second case is grounded on two conventions. It's a convention on the suppression of the financing of terrorism, and a convention on the limitation of all forms of racial discrimination. And actually, let me start from the first case that deals with the genocide. So on 26th of February this year, Ukraine filed an application instituting proceedings against the Russian Federation before the ICJ concerning a dispute related to the interpretation, application and fulfillment of the Genocide Convention. And what was the essence of this case? So the dispute has arisen relating to interpretation and application as Ukraine and Russia hold opposite views on whether the genocide has been committed in Ukraine and whether Article 1 of the Convention provides a basis for Russia to use military force against Ukraine to prevent and to punish this alleged genocide. So Ukraine was accused by Putin of so alleged genocide that was committed on the territory of Lugansk and Donetsk, so-called public republics. Based on this, Russia wanted to justify the war that it had begun against Ukraine. And in its application, Ukraine contends inter alia that the Russian Federation has falsely claimed that acts of genocide have occurred in the Lugansk and Donetsk Oblast of Ukraine, and on that basis recognized the so-called Donetsk and Lugansk People's Republics, and then declared and implement a special military operation against Ukraine. Ukraine in its application emphatically denies that such genocide has occurred and states that it submitted the application to establish that Russia has no lawful basis to take action in and against Ukraine for the purpose of preventing and punishing any purported genocide. In the application, Ukraine also accused the Russian Federation of planning acts of genocide in Ukraine and contends that Russia is intentionally killing and inflicting serious injury on members of the Ukrainian nationality, that is, commit the act of genocide under Article 2 of the Genocide Convention. And on March 16 of this year, the court issued its order on provisional measures, and the court rejected Russia's argument that the court lacked jurisdiction, and it asserted Ukraine's plausible right not to be subjected to military operation by Russia on the basis of alleged genocide. and concluded that Russia must immediately stop its military invasion of Ukraine and suspend the military operations that it commenced on 24th of February in the territory of Ukraine. And the court fixes the following time limits for the filing of the written pleadings. For the memorial of Ukraine, it's 23rd of September 2022, and for the counter memorial for Russian Federation, it's the 23rd of March 2023. And as we can see, the trial will take a long time, but we think that by September 23rd, Ukraine will gather a large evidence base for Russia's genocide of the Ukrainian people. And the second case, please next slide. So the second case was initiated by Ukraine on the 16th of January 2017. So it is before actually the full-scale invasion, and it refers to the violation of two conventions by Russian Federation, and Ukraine claims that Russian Federation violates the Convention on the Suppression of the Financing of Terrorists and the Convention on the Elimination of All Forms of Racial Discrimination. And these cases covers events primarily on the eastern Ukraine and crimes from in Crimea, the territory of the Crimea, from the spring 2014. So yes, before this active phase of Russian military aggression. And regarding the Convention on Financial Terrorism, Ukraine claims that Russia officers, officials and individuals supply weapons, provide funding, conduct training and provide other forms of assistance to armed groups, including the Russian Occupation Administration, so-called Donetsk and Lugansk People's Republics, and other related groups and individuals operating in Ukraine. And with such support, for example, shutdown of Malaysia Airlines flight of MH17 was committed in 2014, which caused the deaths of 298 civilians from 10 countries. And Russia also violates the requirements of the Convention on the Elimination of All Forms of Racial Discrimination and has been discriminatory against the Tatar and Ukrainian ethnic population in Crimea since February 2014 in order to consolidate Russian dominance on the peninsula by destroying the competing cultures, including murder and disappearance of a large number of Crimean Tatar activists and forced expulsion of prominent Crimean Tatar leaders, and by committing another actions. Actually examination of this case is actively continuing because during 2018 till now there were both and oral and written hearings in the Peace Palace in Hague. So it was about the cases in the International Court of Justice. The second judicial mechanism, next slide please. The second judicial mechanism which is used by Ukraine is the International Criminal Court. And International Criminal Court, or ICC, is the first and the only permanent international court with jurisdiction to prosecute individuals. The ICC began operation on the 1st July of 2002 upon the entry into force of the Rome Statute of 1998, and it was like the multilateral treaty, as the Rome Statute that serves as the court's charter and governing document. The ICC has jurisdiction to prosecute individuals for four international crimes, which is the genocide, crimes against humanity, war crimes, and the crime of aggression. And this international tribunal is situated also in The Hague, in Netherlands, but it is important to distinguish it from the International Court of Justice, an organ of the United Nations that hears disputes only between states. And Ukraine signed the Rome Statute in 2000, but didn't ratify it. However, Ukraine has made two special ad hoc article declarations under Article 12 of the Rome Statute. And the first declaration, please next slide. So the first declaration launched by the government of Ukraine in 2013 accepted the ICC jurisdiction with respect to alleged crimes committed on Ukrainian territory from 21st of November 2013 to the 22 February 2014, and it deals with the crimes on the territory of Ukraine in the context of the Revolution of Dignity. And the second declaration were made in 2015 and extended this time period on an open-ended basis to encompass ongoing alleged crimes committed throughout the territory of Ukraine from the 20 February 2014 onwards, so till now. And after the full-scale Russian military invasion, the ICC prosecutor announced on the 28th of February of this year that he would seek authorization to open an investigation into the situation in Ukraine on the basis of the office's earlier conclusions arising from its preliminary examination and encompassing any new alleged crimes falling within the jurisdiction of the court. And on the 2nd of March of this year, the prosecutor announced he had proceeded to open an investigation into the situation in Ukraine on the basis of the referrals received from the 42 countries parties to the Rome Statute. And in accordance with the overall jurisdiction parameters conferred through these referrals, the scope of the situation encompasses any past and present allegations of war crimes, crimes against humanity, and genocide committed on any party, on any part of the territory of Ukraine by any person from the 1st November of the 2013 onwards. And investigators and representatives of the International Criminal Court have already arrived in Ukraine to gather evidence and investigate Russia's war crimes against Ukraine. And the jurisdiction of the court is limited to 4 crimes. Yes, as was mentioned, it is war crimes, crimes against humanity, genocide and aggression, but there is problem in the context of Ukraine with the jurisdiction over the crime of aggression, which is a new one and added by the amendment to the Rome Statute. And I would like to point 2 main challenges in the context of Russian aggression dealing with the ICC investigations toward Ukraine. So due to the Rome Statute, ICC cannot investigate a crime of aggression which requires a ratification of the Rome Statute by both parties or by the United Nations Security Council referral. But we understand that it is impossible in our situation because Russia is a permanent member of the Security Council and will never vote for such referral. And the second challenge is that the court cannot trial individuals in absentia due to Article 63 of the Rome Statute, and it should first issue a warrant for the arrest and then transfer to court. So it is also extremely challenging and practically impossible in our situation. History shows that it is very difficult to prosecute high officials as long as they remain in power. But at the same time, we must remember, for example, the case of Slobodan Milosevic, which was convicted by the International Criminal Tribunal for the former Yugoslavia, but this case has been pending for 20 years. So unfortunately, the proceedings in international courts are not so fast. And if you're talking about the third judicial mechanism, next slide please, it is
we're just in the interest of making sure we get to our other two speakers, could we possibly come back to the European Court at the end?
Okay.
Would that be okay? And then we'll circle back to this if that's all right.
Okay.
Would you be able to come back to these slides afterwards?
Okay, so let's talk not about the European Court of Human Rights. The next slide is about the other judicial mechanisms. And there are also other judicial mechanisms to hold Russia and its officials accountable for the aggression against Ukraine. And actually now it is a very topical issue to find another additional mechanism. And while Ukraine can try perpetrators,
in Ukraine now.
perpetrators of the crime of aggression, it cannot prosecute Vladimir Putin, who enjoys immunity as head of the state. And as for the International Criminal Court, it can legally indict the Russian president, but not for this crime, as it does not have jurisdiction over the crime of aggression. And the best way is to create the ad hoc international criminal tribunal. And the international community actually is currently actively discussing the issue, and a number of national and international bodies have already supported the idea together with the governments of the states. So, for example, the Parliamentary Assembly of the Council of Europe, in its resolution dated 27 and 28 of April of this year, has called on all the organization's members and observer states to urgently set up an ad hoc international criminal tribunal with a mandate to investigate and prosecute the crime of aggression allegedly committed by the political and military leadership of the Russian Federation. The next is the European Parliament. Yes, it's the main institution of the European Union. It's also adopted resolution, and it supported the creation of that special international tribunal. And also it calls to provide as soon as possible all the necessary human and budgetary resources and administrative and investigative and logistic support for the establishment of this tribunal. Also, there was a declaration of the NATO Parliamentary Assembly, which also supported the creation of such a tribunal. And also there was the resolution of the Sejm of Lithuania, which also supported the creation of such international criminal tribunal. And also our Ukrainian Foreign Minister Dmytro Kuleba, it's officially requested the support from G7 countries and the Council of Europe for the creation of a special tribunal to judge Russia's aggression against Ukraine. And we really believe that such special tribunal for the crime of aggression against Ukraine will be created in the nearest future. And actually, to finalize, yes, the next slide please, to finalize, I would like to stress why it is so important and why it is matters in this situation. We all understand that it would be very difficult to judge Russia, to judge top officials of Russia, but it is very important to do so to protect peace, to protect human rights and all international legal order. And also it is necessary to punish Putin and Russian leadership accountable for the aggression in Ukraine. And the history shows that it will be possible, maybe not right now, but in the nearest future, in the long perspective. And also it is important because the decisions of international courts should provide us the legal basis for reparations, not only for the country, but also to compensate damages for civilians which suffered actually from Russian military aggression. And it is also very important to hold the Russian leadership accountable so that the rulers who decided to do such horrible things in the future will know for sure that they will be held liable and will be punished for their aggression. So that is why it's really very important to use all these judicial mechanisms. And if I can come back to the European Court of Human Rights, yes?
Maybe at the end, once we've gotten through the other two presentations.
Okay.
Just because we've got half an hour left.
Okay, thank you very much, and thank you for your attention.
Thank you so much, Darina. Alessia, Darina described one of the things that happened after 2014 and Crimea as the opening of a new front in a legal sense. Taking it from a trade perspective, perhaps you could talk us through what that looked like, what that front looked like from law, and of course any personal reflections you have as well.
Thank you, Dmitry. Good afternoon, good morning, good afternoon, everybody. Thank you very much for Queen's University and the International Institute for Sustainable Development for hosting us. I will be frankly with you, as a trade lawyer, being in Geneva quite a lot of times, it should be a dream, a kind of dream realization that I'm speaking on a panel, on a separate panel in Geneva, being headquarter of the WTO. But the bitter feeling is that the cause for such event is actually the war in my country. And the sound that you have heard, I apologize for it, but this is a sound of alarm. It means that some missiles had been just launched to Ukraine. And this, I have a special app in my phone. And this sticks to this precise region where the rest of my family is now. And this sticks to the region that is not on the east, which is quite shallow, I mean the south and east. But this is much closer to the Belarus and Polish border. So hopefully our anti-missile system works actually, but in a couple of hours we are going to see in some news feed how many missiles there have been launched, where they had been landed, and whether some of them were just stopped by Ukraine's anti-missile system. And, well, this is the point I should start my presentation, because apart from being a professional and trade lawyer, we are human beings, and this is not about figures, claims. This is first of all about people. And yeah, I just want to leave this picture behind on the screen. This is how Ukraine's fields look like now. So the food security crisis is one of the core topic on the ministerial conference here, and this is quite fair that the WTO has concerns of it, but as lawyers, and mostly we are lawyers here, the core issue is a causal link. So this is for you to think what was the cause for such a crisis. I mean the aggravation of crisis, because it has existed before the war launched, and the cause is actually the aggression of Russia. But coming back to specific trade issues and to the question which you have raised, the trade tensions between Ukraine and Russia started long before February 2024. And the trigger was the annexation of Crimea in 2014 and invasion of eastern regions of Ukraine, part of Donetsk and Luhansk regions. It was not the trigger, it was the timing actually. What was the trigger? Decisive move of Ukraine towards the EU democratic choice and EU-oriented values. So this was a sign for Russia that it's time to act. And if you have followed the events in Ukraine, how actually the war started, it started 8 years ago, and it was preceded with the internal revolution in Ukraine, political events in Ukraine that Russia just considered as something that is dangerous for its system. So coming back to trade, in terms of given that the geographical neighborhood, of course, the trade between Ukraine and Russia had been active. And in 2014, 14 it dropped from about $14.8 billion to $9.8 billion. And I'm talking about export of Ukraine to Russia. And in 2021, export of Ukraine to Russia dropped to about $3 and $4 billion. So you can imagine the effect on trade. While export from Russia to Ukraine also was decreasing. In January 2014, Russia started banning some products from Ukraine, and actually I remember that because we, as a law firm, we prepared the news releases for our clients. So it was about pork, it was about cheese, it was about beer, beverages, railway machinery, actually what brought to the dispute at the WTO. And this, of course, was followed with some measures from the Ukraine side. So the story behind it starts quite long ago. And at the end of the day, the law community, trade law community, just faced trade disputes between Ukraine and Russia, and frankly, the point that was raised that disputes, some of them are very important for development of the WTO legal system. I mean, dispute settlement system and treaty interpretation. We are talking about the interpretation of freedom of transit, of course, of the security exceptions under Article 21. So which cases am I referring to? First of all, the case brought by Russia against Ukraine on anti-dumping measures against ammonium nitrate. This is what I call the saga about fertilizers in Ukraine, because actually Ukraine had started to impose anti-dumping duties on imports fertilizers from Russia in 2008. Anti-dumping duties that had been renewed and reviewed, and actually, the claim was brought by the exporting country affected by this measure. The second case I would refer to is Russia railway equipment. The case brought by Ukraine this time on a violation that Ukraine considered to be in place, violations of TBT agreement with regard to suspension of the certificates and denial of issuance of new certificates of railway equipment. So it was about technical barriers of trade and non-recognition of conformity assessment of certificates issued by other Russian partners such as Belarus and Kazakhstan, which form the customs union, the Eurasian Economic Customs Union, together with Russia. So it was the second case. And the third case is Russia traffic in transit. The measures on the ban, actually, the case dealt with de facto discrimination of freedom of transit via the territory of Russia to the territories of its trading partners, and de facto actually to territories of the third countries. And the products at stake were not only those originating in Ukraine, but those originating in EU, Canada, their allies of Ukraine, which products fell within the scope of ban that had been imposed by Russia earlier. And the fourth actually example also deals with anti-dumping cases, anti-dumping measures. There are three claims brought by Ukraine at the WTO, and those disputes are frozen as de facto frozen at the moment with regard to the anti-dumping duties imposed by the Eurasian Economic Union against imports of pipelines from Ukraine, and the disputes were initiated against Russia, against Kazakhstan, against Armenia and Kyrgyzstan. So 4 claims actually, because Eurasian Economic Union is not member of the WTO, so Ukraine filed the separate claims against all the members of this organization. This is quite an overview. Dmitry, maybe you would like me to follow up on the Q&A sessions. What we see now, I understand that actually Irina also has, has to speak. What do we see now? The losses for Ukraine coming from this war are, well, they are absolutely unprecedented in the modern European history, and the Ukrainian think tank, Kyiv School of Economics, now assesses as of 8th of June that the damages to infrastructures is about $103 billion. So we are talking about schools, railway routes, granaries, oil depots, medical institutions. So about social, first of all, about social infrastructure. The most targeted industries that suffer economically are, of course, steelmaking industry of Ukraine, export of foods. So actually now Ukraine has planted, at the end of May, Ukraine has planted about 75% of the lands actually in Ukraine. So under shelling, you have to understand that this is done under shelling, and farmers can be just like killed, they can be hit with landmines that are left by Russian troops on the liberated territories of Kyiv region. So this is like just among all these that is on the screen, Ukraine continues its planting and crop season actually, and the issue is how to actually reblock the export routes. So my point, the third sector that is mostly targeted is oil refinery. So this is according to economists. There are other industries. What we see as lawyers, working with Ukrainian companies, with our clients, some of them just accept that Ukraine would open door for imports, and this is quite reasonable expectations. But we as lawyers would not be surprised to see some protectionist measure of Ukraine, which should be perfectly justified, because there are industries that had to survive and has to be renewed in order to actually, for economy to go on in war and post-war period. And this is this balance, seeking balance between liberalization Ukraine actually seeks for and let's say civilized protection of the areas which are sensitive for Ukraine's economy is now what we are going to see and what the Ukraine's government is about to deal with. I would like to speak more actually, and please I invite your questions and would be happy to give floor to Irina.
Thank you so much, Alessia. Irina, it almost feels perverse to take the focus off Ukraine somewhat and look at the international response from a sanctions perspective. But the obsession in the West has been over the sanctions regime, its effectiveness, who's part of it, who's not, what's in, what's out. And if you could just talk us through the history of it, the effectiveness of it, and what your research has revealed.
Good afternoon, it's already afternoon. Okay, thanks. So yes, indeed. I will try to be brief because in fact there are a lot of information and I think a lot of headlines capture sanctions debate from both sides of the spectrum. And can you put next slide, please? So I will immediately start with showing what countries impose sanctions. So G7, immediately after the invasion, they issued a statement and they actually did a lot of work on coordinating their efforts into imposing similar sanctions. So as of now, all the G7 countries impose more or less similar sanctions with some sort of exceptions. As of now, I counted, and yesterday actually I double-checked how many countries impose sanctions. As of now, 48 countries impose sanctions. Among these countries, I would identify three groups of countries. One of them is the countries so-called what I call frequent users of sanctions. For example, United States, European Union, because for European Union they impose sanctions as a part of their foreign policy agenda, as well as Canada, United Kingdom. Then there is a second group of countries which use sanctions but not as often as the sanction setters at the United States. So to this group I would say belongs Japan, South Korea, to a less extent Australia and New Zealand. And then the third group of countries, it's the countries I was very surprised to see them on the sanctioning side actually. It's some small countries like San Marino, Andorra, Albania. So I was very surprised and I even double-checked if these countries literally introduced sanctions against Russia. But in fact they joined sanctioning efforts, so as of now I counted 48 countries that sanctioned Russia. Also I did calculation of countries that explicitly said that they will not sanction Russia. And among these countries, South Africa, Turkey, China, Indonesia, and a number of other countries. So in total, 9 big countries explicitly stated in diplomatic statement that they do not envision sanctions in any time soon or at all. Next slide. So what I was trying to do in order to, as a preparation for this presentation, I was trying to group the sanctions into different categories. Because in fact, the sanctions are quite comprehensive. There are many different types of sanctions, and because all of these sanctions belong to so-called group of unilateral sanctions that are imposed according to the domestic laws and regulations of the countries that impose it. So it's not collective sanctions, like for example, US authorized sanctions. So there are many differences in sanctions, but in general, I try to group them in a number of categories. So some of them you can see, and I would clarify just a few of them. For example, we have seen quite broad personal individual sanctions. Usually this type of sanction includes freezing of personal assets, which include also real estate and all the potential interest, including bank accounts and even in some cases contracts, future contracts. We have seen these sanctions imposed not only on political elites, but also on so-called economic elites or oligarchs, as well as what is interesting, we have seen also media managers or so-called propagandists being included in this list of sanctions. This is something interesting, that it's not only people who have political or economic power inside of the country that were sanctioned, but also people who work for the media and who spread misinformation. From sanctions which probably are the most unexpectedly, or the ones that one can assume were not expected by Russia, are freezing of their central bank assets. And it's quite substantial, because as of now, there was some estimate that $650 billion is the total amount of assets of this Russian central bank, and half of them were frozen. But countries like United States, European Union, and United Kingdom, and so some of the assets which were outside of the country, they are actually now frozen. They're not expropriated. It should be distinguished, so they're just frozen, so they couldn't access them. It doesn't mean that they now belong to Ukraine, because there are some media reports that this money should be transferred to Ukraine to rebuild it, so it's not happening. As of now, they're just frozen, so basically Russia couldn't access them to use them as in some sort of sanctions avoidance practices. Sanctions against financial system, I grouped them roughly, but what it includes sanctions on some private banks, so some assets also of private banks were frozen abroad, as well as interest and sanction. They couldn't access payment system in the US dollar, in pound sterling, and also in Japanese currency. So what it means that their corresponding bank accounts for this sanctioned bank, they were closed. So basically they couldn't use these currencies as a way of paying for certain services or goods. And some other very interesting sanctions is transport sanctions. So there are two subcategories in transport sanctions. First of all, I don't know to what extent you follow this, but there was ban on flights, on airplanes flying over the territory of a number of countries. So basically now the most frequently used transportation hub is Turkey. So people who want to travel from Russia to Europe or to other countries, they usually use Turkey as a place which still didn't introduce this airplane ban, because all the other European countries introduced this ban. So basically they withdrew flying and landing rights from their airplanes registered in Russia or owned by Russian airplane companies. And second type of sanctions, it's sanctions against ships which were registered in Russia. So these ships cannot enter ports of a quite significant number of countries that introduced these sanctions. And energy sanctions, probably the most heatedly debated type of sanction, because Russian economy, well, it's well known fact, it's heavily dependent on the export of hydrocarbonates, and there was a lot of debate also primarily in the European Union, which is heavily dependent on these supplies, to what extent they should cut off or phase out their dependence on the Russian gas, oil and coal. So with the coal and oil, there was some sort of agreement, so they decided to phase it out and use less, and it was also part of so-called six package of sanctions. But with respect to gas, there was no such kind of strong debate, but it's mainly explained by the extremely heavy dependence, especially among certain countries such as Germany, on the gas supplies, and very strong, obviously, lobby of the industries that depend on these supplies. And technological sanctions, I find them particularly interesting because this is actually export prohibitions to export advanced technology to Russia. And it not only includes so-called dual-use goods. So there has been in place some system of export controls for dual-use goods, and dual-use goods, it's these goods which can be used for military and non-military purposes. But when we are talking about these technological sanctions, they also include some advanced technology which is not per se dual-use goods. Some of them related to aviation sector. And actually, just a couple of days ago, I watched a very interesting analysis of, because now the agenda in Russia is that we will substitute everything. We can substitute everything. We can build our own airplanes. So I watched quite an interesting analysis from perspective from engineers and economists, how fast they can build their own airplanes. And yeah, well, it doesn't seem like it to be very fast. What is happening anytime soon. So I don't have much time to talk about, but there is another symbolic moves, mostly related to so-called sport or cultural sanctions. So there have been a significant number of prohibitions for sportsmen from Russia to take part in almost all the major competitions happening around the world. So, but this is kind of mostly more like a symbolic meaning. I would like also to bring to your attention a very interesting database compiled by the Yale School of Management. Next slide. Sorry. Yale School of Management. They compiled more than 1,000 companies operating in Russia, and they have a great team of people working on this project. So actually what they're doing, they're analyzing what restrictions countries have introduced on their operations in the Russian market. If they're staying, if they curtail, for example, investments, or if they just leave in the market, if they're selling out, because, for example, McDonald's sold out its business in Russia, now it's kind of rebranded and open new, but so it's quite a very complicated narrative, and I would say that this is probably the type of sanctions which not many people expected, because there were some kind of threats to Russia that if it will launch a full-scale invasion, there will be a rapid response, severe response, but it was not stated by private companies, it was said by governments. So this response from private businesses probably was a bit unexpected move, but it's kind of also has its implications in particular on employment and general feeling inside of Russian society. Next slide. I will try to briefly just give a few examples, because in fact Russia introduced quite a number of measures against sanctions. Some of these measures are more like measures of general application, and they are related mostly to preserving the financial stability, preserving currency, and some of these measures are more like of retaliatory nature. I put a few examples which are quite interesting. So what Russia is trying to do now, it constrains severely efforts of non-residents to leave the country. So it prohibits, for example, to sell property, or if you own some sort of securities in Russia, you couldn't sell them without special permission. If you belong to, if you're a national from so-called unfriendly states, and as you see, there are 48 unfriendly states, the exact number of sanctioned countries. So in fact, all the countries that introduced sanctions against Russia are now in this list of unfriendly states. So nationals from these unfriendly states, they couldn't lend money from Russia, they couldn't proceed with their payments, even if they, for example, own some sort of real estate, securities, they couldn't sell it without special permission, as well as since recently there were some restrictions on intellectual property rights. For example, now all the IP contracts should be denominated in Russian currency, and payments can be only done to foreign right owners in Russian currency through the special Russian bank account, as well as, for example, when it comes to patents, there is the Russian entities can use all the types of patented innovations without even getting any type of consent from the right owner and without paying anything. So now it's legal in Russia. Again, it's just a brief snapshot of all the measures. There were much more restrictions, in particular restrictions related to payments, to ownership rights. So they hurt all legitimate businesses who either want to transfer some of their proceeds or to leave market, or people who are foreigners but who own some property inside of Russia. Next slide. Also, I would like briefly tell a few things about strategies circumventing economic sanctions. In fact, there have been a literature discussing these issues, so more or less all of these strategies are well known, but I would draw here, we'll say only two examples of evasion measures. It's first, Russia officially declared that it will allow parallel import. Basically, it prepared a list already of goods which are allowed to be imported from any other third country without asking for permission from the right owner. So, and now, according to the at least plans of the Russian government, they will establish entities in third countries which will buy all the goods or services which they think they are essential for the functioning of the Russian economy. So these entities based in foreign jurisdictions will buy all of this and then will deliver it to the territory of Russian Federation. And second example, it relates to aircrafts. So when this whole war started, there was 800 leased aircraft on the territory of Russia, and many companies that were operating these contracts, they asked planes to be returned to their kind of registration states where they were registered. And because it will cause significant stress for the internal market in Russia, they will have basically no planes to fly around the country. So they decided to land these planes. They prohibited these planes to leave the country. They deregistered these planes, like re-registered, not deregistered. They re-registered them in the national list of planes. So now they have so-called double registration, which is not allowed according to international law. And now they cannot leave the country because then they will be immediately catched by any authorities. So they are trying to use these planes to serve internal market. And now the big question, what the owners or the companies that operate these leasing contracts, what they're going to do, because it's 800 of airplanes. Basically, the number of planes that were not sanctioned is 193. So as you can see, like only a small share of the airplanes could stay in Russia, but now they have changed them even, and they say that they will kind of run technical checks inside of the country. So it raises a whole lot of very interesting questions regarding security of flights and everything, but it's just one of the probably interesting examples. Next slide. I just put this slide like how I envision further possible improvements of sanctions. For example, introducing secondary sanctions, or tightening responsibility, or also I would say that there should be monitoring of compliance by civil society, because I assume there will be countries as well as some companies trying to evade sanctions. So I think this monitoring, which might potentially bring significant reputational costs, will be beneficial for the overall success of sanctions. Last slide. And one of the most interesting questions which we can think about is to what extent some of the assets which were frozen as a part of these sanctions can be used to rebuild Ukraine. Because as my colleagues have already mentioned, there have been a significant destruction of infrastructure, not only military infrastructure, but civilian infrastructure, not talking about the lives that were lost. But so two interesting questions about whether the frozen assets of the Central Bank of Russia can be used, and whether the assets used by frozen assets of private individuals, so-called oligarchs, can be used. And in this respect, two interesting examples. In fact, there have been already a precedent in history where the sanctioned assets of central bank were used to pay compensation to private individuals. It was related to sanctions, to the United States sanctions against Iran. When some of these assets were used to pay private compensation, it was significant amounts of money, and Iran initiated a case before International Court of Justice to challenge some of these practices. The court decided that it falls outside, this particular question falls outside of its jurisdiction, but it's a very technical legal question. And the second is use of funds of private individuals, so-called oligarchs. And as of now, there is an interesting proposal which was recently expressed by Canada that there might be private negotiations between each of these sanctioned individuals, that there are parts of their money will be unfrozen, so they will get access to their funds as well. They will be allowed maybe to conduct some of the business operations. In exchange, part of this money will be violently invested by them or just given away to Ukraine to build itself. So it's still an ongoing process, but I think it will be interesting to follow up. Thank you for your attention.
Thank you so much, Irina, and indeed to all three of our speakers. With IISD's indulgence, we have about 10-15 bonus minutes for questions, because I do want to give you all a chance to ask these eminent experts about their presentations and about their experiences. So please allow me to open the floor, maybe take a few questions. Ron, you're feeling brave?
Yeah, hi, thank you. Very interesting and very informative. I have two questions for Alicia. One is just the picture you showed of the bombed fields. Are those the results of bombs that exploded, or is there a considerable number of unexploded ordnance? Because that would obviously have a big effect on the ability of a farmer to even go near those. The second question was, you talked about protection in the eventual recovery period, and I can understand the argument for that, particularly to make sure that they don't lose market share. But how long are you talking about? And I would hope that the more important policy will be aid from other countries in rebuilding. So, in a sense, subsidies that would be allowed for the rebuilding of previous. I'm just worried when I start hearing about protection, how long that might actually stay in place, because that tends to persist for longer than initially intended.
Thank you for the questions. I will check as for the picture, and we'll be happy to give you more details of it later. As for protection, our idea is that, of course, Ukraine, unlike the counterpart in this, the other party of this war, shows the readiness to cooperate and to communicate and negotiate, with the allies. And of course, we do not expect some outright protectionism. But the idea is, when the new economical strategy, we see, for instance, proposals of localization in public procurement. And this had been discussed with Ukraine before the war, and for example, from the localization requirement, the product originating from the parties to the plurilateral public procurement agreement are exempted. What Ukraine is going to be now, and whether this exemption is going to be actually in place, or there should be some modification because of the needs of specific industries, this is a question, and this is what we are going to see at the table as an example. So another example are the trade remedies. Actually, in March, Ukraine suspended the import duties and charges and VAT related to imports, but trade remedies are not there. And this is also we understand that, for instance, when EU suspends the import duties and charges, and anti-dumping duties and safeguard duties with regard to steel products concerning imports from Ukraine, it's not unconditional. And if we see the text of the EU attentively, there is a clause on safeguards, which actually allows the Commission to reinvestigate launch some investigations if there is a threat from Ukraine's industry for the competitive products. And frankly, I would wish that Ukraine's industry proposes a threat for the market, but unfortunately it's not the case. But anyway, the clause on safeguards is still there. So, I mean, of course we are talking of civilized manner of trade, yes, and protectionism as some tendency which I have suggested to potentially anticipate a part of this civilized dialogue, but it might not be out of the table.
Thank you. And as to your first question, Ron, I mean, modern artillery munitions can have a misfire rate as high as 5%. The Russians flinging stuff they pulled out of a poorly ventilated warehouse from 1971, fired by an artilleryman who doesn't know what they're doing. I think there are probably very, very dangerous things all over those fields that are going to take decades before you even get it to the mines that Alessia was talking about, laid by. Yeah, I think it's going to be, unexploded munitions is going to be a generational challenge for Ukraine, even if the war were to end tomorrow.
Thank you.
Any other questions for any of our panelists? Yes, ma'am.
You discussed the difference in trade and how it's gone down because of your you're no longer partnering with Russia in the same way in terms of trade. Could you illuminate a bit more on plans going forward if you think that as Ukraine rebuilds, if they will change the way that they trade with either any of the associated countries who before the war they had a substantial amount of trade and now it's gone down? Do you see them opening up their exports to a greater number of countries or returning?
Who should take the question?
I suppose you or any of them, but I think it's more directly towards.
If you can add. Thank you very much. Actually, it resonates with some points I have not included in my presentation, so we'd like to take these questions. Indeed, Russia suspended the FTA with Ukraine in 2016, and it was the reaction for the EU-Ukraine FTA coming into force. So this is like a milestone of why trade actually, the framework of this bilateral trade has changed drastically. There is another example how already the war modified some priorities of dates in Ukraine's trade policy. For instance, I remember in January this year, we organized a meeting of the Ukrainian Bar Association with International Trade Law Committee, with Ukraine's international cargo carriers. And the problem was potential dispute between Ukraine and the EU over Polish measures. Poland at that time had declined, had refused issuing the cargo permits for automobile carriers of Ukraine for transit actually routes during the through Polish territory. And we were like seriously considering potential claims Ukraine could bring at the WTO or under the EU-Ukraine Association FTA mechanism. And now I think this is out of the table because, well, there is a memorandum of understanding between Poland and Ukraine. Apart from all the support that actually Poland is actually doing to Ukraine, there is memorandum of understanding which is a signal for trade, liberalization tendencies. As regards other countries, well, there is in the new strategy, at least there are some bullet points. The priority for the governments is now is the market access to G7 and G20 markets, the liberalization actually, which would entail tariff and non-tariff liberalization, but we have to understand that this is a long way actually to be ahead. And yeah, so as I'm not the representative of government, I cannot give you some precise the policy insights, but just a few examples. How it is just now.
Thank you. We have time for about one more last question. Does anyone have anything on the human and international law rights aspects or on the sanctions regime? Yes, sir.
Thank you to all the panelists. I have a question for Irina. I was wondering if you'd be able to elaborate on the point of where you see the use for secondary sanctions and how they could be effective in this context.
Okay, thank you for the question. Yeah, I kind of was short. I didn't have enough time to elaborate on the question of secondary sanctions, again, which are quite often argued to be illegal because of violation of principles of jurisdiction in international law, if you follow this discussion. So, but going back how I envision the use of secondary sanctions. In fact, secondary sanctions are used to enforce so-called primary sanctions. So, for example, if you have now companies pulling out of the Russian market, or we have companies that do not export certain goods to the Russian market. And as I mentioned, for example, one of the ways to overcome this is to organize entities that will, for example, be based in Kazakhstan, as an example. Then there will be kind of Kazakh entity buying goods, but then reselling them, like with a minimum kind of just addition to the price. I mean, obviously it will increase the domestic price of certain components and goods, but the question is that these sanctions were imposed to deprive Russia of access to certain kind of goods, technology, and services. So that's why I envision the use of secondary sanctions in particular to make it impossible to overcome for the primary types of sanctions by establishing these entities under the threat that any such country or any such entity that does it will be facing the same penalties as the primary countries of the sanction. This is how usually secondary sanctions works. And in fact, secondary sanctions against Iran were very efficient, forcing even China to withdraw a significant share of its operations. And the same was, for example, with financial sanctions against Iran that were initiated by the United States. They are so efficient that European banks do not want to cooperate with Iranian banks, even although, for example, European Union allows them to do this. So their domestic regulators allow them to do this, but under the threat to be disconnected, their payable through correspondent bank accounts in the US will be shut down once they are caught. And we have seen also this significant number of cases when, for example, Swiss banks pay billions in the settlements with the Office of Foreign Assets Control in the US in order not to be deprived from the US market. So I envision a role of secondary sanctions as a mechanism to prevent sanctions avoidance and to keep this pressure in economic terms on Russia to review its foreign policy, in particular with respect to Ukraine. Thanks.
Thank you so much, Irina, and thank you to all of our panelists. I think that's all the time we have. I think that was a really good note to end on, which is that I think all of our speakers have spoken about the unspeakable horror and the sheer scale of what is happening in Ukraine. But at the same time, and I'm hoping this is promising to those of you interested in international law and the system, they've also spoken about the breadth of the international response. The fact that as much as many of us feel powerless in the face of the horror, there are mechanisms, there are processes, there are actions that are taking place. There are things that you can be a part of, that our governments can be a part of, that are happening. And secondary sanctions and deterrence is a good place to finish, that some of these things do work. Some of these things are effective, and they are a way of pushing back even in the face of a very large and belligerent power exercising things that appear to run contrary to the norms that the system was built around. So with that, I'd like to thank very, very much Darina, Irina, and Alessia. Thank you so much for taking questions, and thank you to our audience for coming and for listening to Ukrainian voices speaking about the Ukrainian invasion.